Greetings, everyone. Thank you for joining us for this second annual Comparative Animal Law Postgraduate Workshop. My name is Megan Senatori, and I'm the Associate Director of the Center for Animal Law Studies at Lewis and Clark Law School, located in Portland, Oregon, in the United States. This workshop is a joint initiative by leading universities from around the world, and I can say from personal experience that it's been a true pleasure collaborating with our co-hosts. They are the Faculty of Law and Political Science at Aix-Marseille University in France, the Journal of Comparative Law, Kent Center for European and Comparative Law at Kent Law School in Canterbury in the UK, the Nalsar University of Law in India, and the Faculty of Law at West University of Timisoara in Romania. I'd also like to take a moment to extend a very special thank you and to recognize Simone Glannert from the Kent Center for European and Comparative Law and Alexandra Marcescu from West University of Timisoara in Romania. Simone and Alexandra, if you don't know them, are the co-organizers who brought the idea for this workshop to our respective universities, and it is their vision and dedication that has guided us all to this workshop, which is now in its second year. So thank you to Simone and Alexandra. We have a thought-provoking day in store for you with presentations from postgraduate students on a diverse range of comparative animal law topics. Today's students will be joining us from Brazil, Finland, and the United States. But we begin with this morning's keynote address, and I'm honored to introduce our presenter. Professor Amanda Whitfort is an associate professor in the Faculty of Law at the University of Hong Kong, and she's also a practicing barrister. She's admitted as a barrister and solicitor in Australia, and after becoming the first local resident of Hong Kong to pass the Overseas Bar Qualification Examination in 2005, she was admitted to the Hong Kong Bar as well. Professor Whitfort specializes in criminal law, environmental law, and animal law, and she's internationally recognized for her work. She is the founder of the Species Victim Impact Statement Initiative, which is a tool for wildlife crime prosecutions that provides law enforcement authorities worldwide with reliable scientific data assessing the ecological harms caused by wildlife crimes. The SVIS initiative has been endorsed by the United Nations Office on Drugs and Crime and referenced in 10 countries. Her research examining loopholes in Hong Kong's capacity to effectively combat illegal wildlife trade led to the inclusion of wildlife offenses in the Organized and Serious Crimes Ordinance in 2021. Today, Professor Whitfort will be presenting on eco-justice approaches in wildlife crime sentencing. And as our audience, you'll have the opportunity to ask Professor Whitfort questions at the conclusion of her keynote address. So we will be reserving about 10 to 15 minutes at the end of this session for the Q&A, and I'll provide instructions then about how you can ask her questions. So with that, thank you so much for joining us and sharing your expertise with us, Professor Whitfort, and I will turn things over to you.
Thank you very much for that lovely introduction. I will begin when my slides come into the right order. Yep, there we go. Right. Yes, thank you very much for the introduction. And I'm delighted to be invited to speak to you all today about something that I think about all the time, which is how we introduce eco-justice into wildlife crime sentencing. Now, we're all aware, of course, that illegal wildlife trade is a significant problem. It is one of the most significant environmental challenges that we face globally. As a resident of Asia and a long-term resident of Australasia, I am fully aware of the implications of illegal wildlife trade, and it's something that is a real problem for courts, for governments, for policy to address. Unfortunately, whilst we did see some reduction during the COVID years with the transports and the logistical issues, demand for wildlife products is growing. And Asia is, of course, one of the areas where there is huge demand for wildlife for many reasons that I will go into. But the other countries around the world are also complicit in this. And America, as you will know, is a big consumer of wildlife, some of it sustainable, but much of it unsustainable. Now, animals are smuggled for all sorts of reasons. They're smuggled for food. They're smuggled to be parts of medicines. They're smuggled, of course, for the pet trade. And they're smuggled for decorative purposes, sometimes made into jewelry, sometimes skins, furs, and even taxidermy. But along with illegal wildlife trade for those purposes, we also have legal wildlife trade, and that also affects the way that animals are treated from the wild, because many of these are poached into farms. And animals that are wild, that are used on farms, might be being bred for food. They might be being bred in some parts of the world for derivatives to be used in medicine. And of course, wild animals are bred globally to sustain the fur industry. So there's all sorts of reasons that we have wild animals in trade, either legally or illegally, and all of these present issues when these cases come to court as to the approach to be taken in dealing with the offence and the offender. So I want to start off with something that really interests me as a researcher, and that is who are the victims of wildlife crime? And unfortunately, we have had historically a very anthropocentric answer to that question. We don't think about animals as victims, both domestic animals or wild animals in the courts. Animals are perceived as property. We think about the owners of the property. If they are unowned, if they're wild animals, we might think about the loss to the country, the economic benefit, the tourism, etc. But we don't really think about the animals. And that's something that is starting to be better addressed in the literature. And I'm going to suggest to you tonight, it's in a rudimentary way starting to be addressed in the courts as well, which of course is a very positive evolution. Now, this anthropocentric view of animals, of course, comes from this idea that animals are part of our natural resources and that they need to be preserved not for themselves, but because they are a benefit to us as humans. And we see that in the main treaties that deal with trade in wildlife. And CITES, the Convention on International Trade in Endangered Species, obviously is a prime example of that. Now, CITES is about trade. It's about sustainable trade, but it is about trade. It is not about welfare. It is not about this idea of eco-justice, which I'm going to explore shortly. It is very much about sustainable trade. And when we had COVID, of course, there was a lot of discussion about CITES and why hadn't CITES stopped COVID or put some obstacles in the way of COVID, and could it, going forward, do those things? But of course, CITES was never designed for that. CITES says very little about the way that animals are treated. It has some guidance as to how animals are transported when they are sent across international borders, but it's silent on how they are taken. It's silent on how they are in-country transported. And as a result, it really is not a vehicle focused on animals. It's a vehicle for trade. Now, it has some positive effects. It requires permits, of course, for animals to be moved across borders when they are animals that are the focus of the appendices. But it doesn't even require that countries criminalize breaches of those permit controls. It just requires that they are regulated. So it doesn't define harms to animals. It doesn't think about the health and the well-being of animals in ways that perhaps some who weren't looking at it in great detail had perceived that it might during the time that we were in discussion about how to deal with COVID. So we really have this problem that wild animals are left out of the law. They are regarded as an other, and domestic animals to an extent, but for domestic animals, at least we have animal cruelty laws, which may affect wild animals in some situations, but not all. And that's because, of course, of the duty of care. And it's a problem for wild animals that they are left out of the loop. So this utilitarian attitude towards animal usage runs through the treaties, and I'll come to the Convention on Biological Diversity shortly. And it is something that unfortunately has influenced the way that we deal with wildlife crime and the way that we perceive it as, in many cases, merely a regulatory problem rather than a truly criminal problem with real victims. So looking at conservation and welfare, and this is a issue that comes up a lot in the literature, and it's something that I'm very interested in. International treaties like CITES, which I've mentioned already, and the Convention on Biological Diversity are, of course, hampered in their ability to deal with animal protection because they have conservation objectives. And if we delve into the conservation literature, we find that welfare is actually a dirty word, that welfare is not something that is promoted within conservation biology, because conservation biology bases the idea of harm to the level of threat to a species at any given time, and of course to its ecological value as perceived by conservation biologists within the ecosystem, which means that individuals are entirely overlooked. And it has been a real battle for welfare to become something that is taken into consideration in the world of conservation protection. Now, we have movements such as Compassion in Conservation, which have actually helped very much to move these ideas forward. But diehard conservationists will essentially say that the idea of individual animals and their welfare is not something that they need to take into account when they think about conservation. And CITES and the Convention on Biological Diversity are conservation treaties. So the idea that animal welfare can be protected through them is something that is very, very difficult to promote and sustain. There's also, of course, this problem that I've raised already as to who is accountable anyway for the welfare of wild animals. When wild animals are considered on the basis of welfare, it's normally because a government has taken a position that they need to be culled, and some group has decided that they need to oppose that and consider the welfare of the species. But it's really coming from the back end that welfare starts to be considered in relation to wild animals, because nobody really has a duty to them under the law unless or until they come into captivity. So there is this also other question that is coming in on top of the complications that I've already described, that law doesn't really think about who's accountable for wild animals. Because of course, under the old common law, you couldn't own a wild animal unless you had it captive. And of course, if it ran away, it was no longer yours. And that really does permeate through our ideas about wild animals up to today. So all of these problems factor in and move against us thinking about wild animals as victims, thinking about their interests, and thinking about their needs as far as the law can protect them. So what I'm going to talk about next, of course, is green criminology, which is a big interest for many researchers in this area. Now, legal systems, of course, are a human construct, which is a wonderful thing because it means that we can challenge them, we can change them if we work hard enough, and we can certainly imagine a world outside of them, even if our challenges are taking a long time to achieve. So if we can reshape our views about society's responsibility towards wild animals, being influenced by our growing environmental awareness, and that's something I think that we have the opportunity to do at this time, then this is something that we can hope may change the future. So criminology, from the perspective of wild animals, promotes a wider definition than the one that I've just described in relation to wildlife offending. So with its focus on eco-justice, humans can be viewed as just one part of the wider ecosystem. And species justice, which is something that we see in the writings of Rob White and Tanya Wyatt and others that you'll be aware of, talks about permitting both the direct harms to animals in poaching and trade into this idea of what we owe animals, but also the indirect harms to non-target species that, of course, are affected when species are taken from their ecosystems. And that's something that, of course, is the core of my project, the Species Victim Impact Statement Initiative, which I'm not going to talk about tonight. But that's the idea, that we should be addressing these wider harms. So wider harms to individual animals, and of course, remember, individual animals are not generally considered within the conservation world, but also harms to ecosystems through habitat degradation and removal of species, which is something that is, of course, at the core of conservation. So some of my writing has been about this idea that welfare and conservation are not opposite sides of the coin. For wild species, that we all move forward when we think about these two things together, that we consider individuals and we consider ecosystems. And if we do those two things, that we will start to move towards a better discussion about what wild animals need. And of course, this kind of approach is consistent with the Sustainable Development Goals. It's something that people are thinking about more in the wake of COVID-19, and I'm hoping that it will start to have its time. So I'm going to start off talking about, well, actually, I'll talk about two countries. And the first one, of course, is China, because people tend to have a lot of views about China, many of which are perhaps a little naive. And I want to talk a bit about some of the positives that we've seen in case law coming out of China. Now, I'm not going to suggest for a moment that there is green criminology growing in China, but I do want to suggest that some of the case law is showing this rudimentary recognition of ecological harm as a basis for a more deterrent sentence, or being treated as an aggravating feature in the way that wildlife crime is treated. But first of all, we need to set the context. So if we talk about China, the first thing we need to recognize, of course, is that there's not just illegal wildlife trade. and poaching and hunting, which are things that we have in all parts of the world. There's also something that we don't see in all parts of the world. We do see it a bit in Europe, we do see it a bit in the US, but we see it more in Asia, not just China, more in Asia, and that is wildlife farming. So we do have wild species that have been domesticated for wildlife farming, and we do, of course, everywhere there is wildlife farming, have laundering of wild species into wildlife farming. Now, wildlife farming is something that has been going on in China for over 75 years. It was in the 1950s when the CCP issued a series of directives to encourage the utilization of wild species for derivatives for medicine through their farming. And the successive wildlife protection laws that have been passed since that time have all re-emphasized this idea that wildlife farming is a positive, that it allows for conservation because it means that wildlife will not need to be taken from the wild for these purposes if we can develop a sustainable farming system whereby we can provide the animals from within that system. And certain species have been singled out for farming and also for increased protection under the law on the basis that they are of use in farming and therefore of economic use to the country. Now, this, of course, is a very utilitarian view of animals. It's a user view. But of course, this is not unique to China. And this is a utilitarian view that we see in many countries in the world. And it's certainly not an Eastern view of the way that animals should be utilized. It's a global view. Of course, all of this had to be rethought with COVID. Before COVID occurred, wildlife farming in China was valued at about 60 billion US dollars per year, and it employed over 14 million people, many of which were living in rural areas and really had no other way to sustain their families. So it was a very important factor for China. And as a result of COVID-19, a lot of that was shut down. And that was due to a direct recognition that wildlife farming, of course, has zoonosis risk, that farming wildlife, just like farming domestic wildlife, carries problems for society, not just illegal wildlife trade problems, but also problems for public health, and that needed to be effectively and nationally addressed. And this led to the Standing Committee's statement in 2020 that there would be a nationwide prohibition on farming of terrestrial species for food. Now, that means that you can still farm aquatic species. It also means that you can still farm species for other purposes. So it is still possible to farm animals for fur in China, and it's still possible to farm animals for medicines, which is protected under the wildlife protection law and promoted under the traditional Chinese medicine law. But it did show a commitment to dealing with this issue. And remember the number of people that were employed in this. Now, some of these wildlife farming operations were encouraged to pivot to farming their animals for medicines. And there are some animals that were being bred for multi-purposes. So civet, for example, was being bred for fur, for medicine, and for food. So some of these farming operations were able to pivot to other uses, but for others, this was a problem as far as employment is concerned. But it showed a real effort to address the issue and to try to contain it. And at the same time, of course, there needed to be supplementary changes to the law, so the husbandry law and the epidemic controls of course, needed to be ramped up as well. And of course, we need to see how this plays out. But we do see far less of this kind of practice going on, and there is a lot more enforcement action being taken as a result. So that's wild animals in farming. I'm going to come to them in smuggling in a minute, because smuggling is quite different. It's very interesting when you look into this, how different the views of China have been about wildlife farming pre-COVID and illegal wildlife trade. Wildlife farming, of course, was always promoted. Illegal wildlife trade has always had a hard line. But what we're seeing now, and that's really what I want to talk about, is this filtration across both of this idea of harm to animals and the need to consider their health and even their welfare in a way, which is something that is quite anti-China law, because, of course, as you will know, China doesn't have an animal cruelty law. What it does have, though, or what it did have pre-COVID, was a protection for the welfare of endangered species in captivity for breeding. And since COVID, that's been expanded to a protection for wild animals in captivity, whether they're endangered or not, as far as their welfare is concerned. Now, of course, there are many steps to go. We need standards, we need better enforcement, et cetera, et cetera. But there is a recognition that has come out of COVID, which is a positive step towards better protection of wild animals. And I would suggest that's coming both from this health idea and the recognition that we need to consider one health, and of course one welfare starts to become the next idea. But it also comes from this idea that was already permeating through illegal wildlife trade, that we need to think about the animals themselves. And that's what I want to come to next, that this idea of ecological harm, it's small, but I think it's starting to help fill this lacuna that we have of the welfare of wild animals in China. So looking at 3 cases that I want to share with you as examples. The first one, I mean, they're all 2019. The first one is, so they're all pre-COVID, and I think that's important. And I picked them on purpose because I want to show you that COVID hadn't happened yet. It was in the stages, but it wasn't a declared a pandemic in China, and there wasn't a recognition of COVID at this point when these cases came through. But they show a recognition of China's responsibility to protect the global environment through cracking down on illegal wildlife trade. And the first one is from Boshan Intermediate People's Court. This was the conviction of 5 people for smuggling pangolin and gibbon skulls, both Appendix 1, CITES species. Now, this is contrary to 2 laws in China, and I haven't mentioned them, so I'll just mention them briefly now. The first one is Article 151 of the criminal law, which prohibits the smuggling of endangered species. And the second is Article 341, also of the criminal law, which prohibits the hunting, trading, and killing of endangered species and state-protected species. So that includes rare animals, and it also includes those animals that I mentioned before that are considered important for economic value to the country. So the defendants' sentences in this case ranged from 11 years imprisonment and a fine of $15,000 down to, for a peripheral offender, to a suspended sentence of 1 year. And in the judgment, the judge emphasizes the global environment and the need for China to protect the global environment. Now, it's important that you understand that this is significant in a Chinese court, because what's often pushed in a Chinese court are national interests. Is this a problem for China? If it's not a problem for China, then perhaps it's not such an aggravating feature. But what we're seeing in these cases is a real recognition of this need to protect global environmental concerns rather than simply national environmental concerns. So where smuggling is detected, it's important for China to live up to its oath to promote CITES. And the second case, Xishan District People's Court, this was a case under Article 341 of the criminal law, which is the trading of endangered species. This one related to the illegal buying and selling of over 180 Appendix 2 CITES listed tortoises. And the court in this case imposed a sentence of 3 years imprisonment and a fine of $8,000 on the defendants. And the defendants pushed back because that is a reasonably significant sentence for tortoises. Tortoises are widely recognized as being under-sentenced in illegal wildlife trade because people tend not to think about these non-charismatic endangered species. And judges are no different to the rest of us. They don't really think about tortoises. But in this case, the judge did consider this a serious crime. And 3 years is a serious crime sentence in China for smuggling and trading in endangered species. And the defendant claimed that as his crime hadn't caused any ecological harm to China, because all of these tortoises had been smuggled in, they'd been taken from other countries across the world, then this was unacceptable for him to be sentenced at such a high level. And he got pushback. The court said that all illegal trade and transport of endangered species affects the balance of the ecosystem. So not is a breach of CITES, which would be an understandable position for the courts to take, but no, it was that it was affecting the balance of the ecosystem. It didn't matter where the trade originated. This was an aggravating feature. And on appeal, this sentence was upheld. And then we come to the third case. This is another 2019 case. This one was in Yantai City, where the intermediate court upheld a lower court sentence of 10 years imprisonment and a fine of $6,000 for buying, selling, and transporting valuable animals and products made from them. I mean, products used in a loose sense, because these were parrots and parrot eggs. So the defendant had a license to breed parrots, yet he was prosecuted. Now, again, this is a very interesting choice of prosecution for China, because generally once a wild animal becomes domesticated, then it's no longer considered wild as far as the courts are concerned. But in this case, there was proof that this defendant had smuggled in certain animals that he had in his possession for trade. Some he brought from Guangzhou, which is a city at the border of Hong Kong, from a supplier without licenses. So again, they could have been captive bred, which would normally lead to China regarding them as domesticated species, and this kind of prosecution would not take place. But there's a wider view being taken by the judge. And the judge treated this as a serious case, both because animals that may or may not have been bred had been moved around China without licenses. And secondly, because, and this is more consistent with normal Chinese case law, some other parrots that were involved in the case had come from eggs which had been smuggled into China from Thailand by the same Guangzhou supplier. And the first instance court here said, look, the focus of the wildlife protection law has got to be on protecting valuable and endangered wild animals for the purpose of biodiversity everywhere, not just within China. So we need to think about the original habitats of these species. We need to stop poaching of wild animals. And we need to stop, and this is where as I suggest to you, it's quite interesting, and it starts to move into this idea of captive wild animals and protection for them. We need to stop poaching of wild animals for pets, even though in this case, it couldn't completely be shown that these were not captive bred. So all of these are showing a more expansive interpretation of the general CITES mindset, that it's about sustainable use, that if you've got the permit, it's one thing. If you haven't got the permit, it's a regulatory offense. And also the normal Chinese perspective, which is national interests, and then promotion of international trade, of course, but in a very regimented manner. So I think it shows imagination. It shows a positive step forward, and it's something that has continued on. But I particularly wanted to focus on these pre-COVID cases, so it wouldn't be suggested that this was simply the result of COVID. And I'm not suggesting that COVID isn't playing a part, but what I want to show is that this was taking place before COVID became an issue. And China, of course, is very much a destination country for illegal wildlife trade. But Australia is a source country. So I want to also look at some Australian cases, which are showing a similar trajectory in the way that the courts are starting to think about illegal wildlife trade. So I have two cases that I want to look at. The most significant illegal wildlife trade decision in recent years in Australia is the Queen and Martin Kennedy from 2019. In that case, the New South Wales Court of Criminal Appeal was asked to consider a 3-year intensive order in the community that had been given to a famous sports star in relation to his smuggling of wild species into Australia and out of Australia. And in that case, his sentence was changed to imprisonment, one of imprisonment, 4 years imprisonment to be served in relation to his breaches of the environmental law. In 2016, Kennedy, the defendant, had attempted to twice export by mail to Sweden 33 shingleback lizards, and you can see that one of those lizards taped up. This is the second case, but you can see a shingleback lizard on the screen there, along with 10 turtles, all of which were native species of Australia and subject, of course, to possession controls. He attempted to export them to Sweden. And during the same year, he arranged to import soft-shell turtles, alligator snapping turtles, snakehead fish, tropical stingrays, sugar gliders, and veiled chameleons, all over 100 animals, Appendix 2 animals from Thailand into Australia for obviously what was a pet breeding and supplying business on an illegal number of species. On arrest at home, he was found to have 2 pythons of Appendix 2 CITES listing, along with about $40,000 in Australian money, which was considered to be the proceeds of illegal trade. And in assessing the seriousness of the crime, the judge did something interesting. He not just heard from a law professor about the extent of international wildlife trade, the growing problem that it's become, the legal frameworks that we're all trying to use to prevent it, how they're failing or succeeding at a very low level. He also received 2 reports from ecologists. And these reports were really instrumental in helping the judge to understand the depth of harm in this defendant's actions, both as far as environmental harm and invasive species risk, which of course is a big factor for Australia as an island, but also disease risk. And the judge, to his credit, also considered the impact of cruelty in the trade. Now, cruelty was not a charge on the indictment, and yet it became a significant aggravating feature in the way that the judge considered the harm in this case. And this comes back again to my point of this idea of harm to individuals as well as harm to ecosystems. And we are starting to see it in a way that 20 years ago we did not see in wildlife crime cases. So yes, it's a small step forward, but it's a step forward, and it's something that we need to be aware of and considering and, of course, promoting. So the second case is the Queen and Chin. The defendant here was a man living on a tourist visa in New South Wales. He was sentenced to 3.5 years imprisonment. He was charged with mailing Australian reptiles, and this is one of his victims in the picture on the slide, to Hong Kong. Obviously for the illegal pet trade, some of which of course occurs in Hong Kong, but a lot of which occurs in China, because it's very easy to transport animals once they get to Hong Kong over the border into China by trucks, by speedboats, and by ferry and other ways. This carries, his crimes carried a maximum penalty of 10 years imprisonment. None of these animals are CITES listed. They are all just protected animals within Australia. They were concealed in parcels. They were concealed, they were tied up to restrict their movement. And you can see here the taping of this animal, which causes, of course, some of them to suffocate, and then tied into wet socks in the hope that they might survive the postal system. But of course, most didn't. Anyway, the judge, of course, not only considered the fact that these were animals that Australia wanted to protect, and since that time, there's been a move by the Australian government to have them listed in Appendix 3 of CITES, but also the cruelty to these animals. And in considering the sentence, which was decreased on appeal, one of the things, though, that the judge held on to on appeal was the suffering of the animals and the indifference of the defendants to their suffering. Now, not so long ago, you would have seen judges that wouldn't have recognized the suffering to these kinds of animals, certainly to mammals, certainly to charismatic animals, but not to these kinds of animals. So this is really something that is important when we think about the growth of protection for wild species. This rudimentary but certainly present idea that there are harms to species that perhaps we wouldn't normally think about, that we should be starting to think about when we sentence for wildlife crime. And Q's case, I'm just going to leave that. It's a similar case, but I'm running out of time, so I just want to move on to my conclusion. I've slammed CITES, I always do, but I want to emphasize that wild species are an undeveloped area of focus in international law, and that CITES with its eye on animals as a resource, has unfortunately helped for that to be a global position. Now, vet-led emphasis on One Health and One Welfare has begun, particularly since COVID, to be more recognised. And of course, that provides an emphasis on welfare in breeding, transport and trade practices for wild animals, all of which are more under the spotlight as a result of our increased awareness of zoonosis and the link between animal health and animal welfare, which vets have always tried to get us to pay attention to, but it's taken certainly the lawyers and the courts quite a long time to recognize these things. The Convention on Biological Diversity in 2017 started promoting biodiversity considerations as part of the One Health approach. That's positive. And the OIE, which I've not mentioned in the slide, of course, also is the champion of One Health, One Welfare. But for the CBD, those guidelines have started to suggest that ecosystems should be managed for the sake of their intrinsic value, as well as the benefits they provide to humans. Now, of course, the CBD has no teeth, unlike CITES, but at least there is recognition, and as more and more countries become members of the CBD, this is something that can be promoted. And the CBD emphasizes more effective control on illegal wildlife trade, of course, due to its inherent risk to the planet, to humans, and of course, to non-human animal health. But the thing, the elephant in the room, and I've used a tiger, the tiger in the room, the thing that we need to start to focus on more, and that we need to encourage within our courts, within our thinking, within our writing, is this idea of eco-justice. So our capacity, my message is, to protect endangered species and recognize the harms we do to them in trade would obviously benefit from better legislation, from what we're all working towards, a global treaty recognizing the welfare of sentient animals, including wild species. But these things are works in progress. Meanwhile, wherever we can, we need to encourage the application of eco-justice approaches to the way we consider illegal wildlife trade, and either as international smuggling or as wildlife farming. And we're starting to see that in the case law that I've discussed tonight. So in the absence of a global animal welfare treaty, I want to encourage us to think about eco-justice approaches as a way to start to fill the lacuna, as something that even within the current legal system, we can get behind. And that's something that is very much at the core of the work that I do with the Species Victim Impact Statement Initiative. Thank you very much for listening, and I'm really happy to take your questions.
Thank you so much, Professor Whitford. We really appreciate your presentation. You've given us a wonderful framework to consider, and it's encouraging to see courts, finally considering some of the individual harms to animals, and it sounds like the eco-justice approach is part of the pathway to get there, so we appreciate that. We are out of time for questions. We are available. Oh no, but you answered so many things that you've anticipatorily answered our questions. So thank you very much. If anyone would like to get more information about the work that you presented today, Professor Whitford, where can they locate that information?
Oh, you can contact me directly, or you can look at my Species Victim Impact Statements website, which is the Hong Kong Youth SPIZ Initiative, or some of the writing that I've done talks about a lot of the issues that I've talked about today.
Thank you so much. And I will add some of those into the chat during the conversation today. So thank you so much for your time, Professor Whitford. We especially appreciate it because it's very late where you are. So thank you so much. And we're going to now turn to our first student